said, my name is Sofia Johnson. I'm an attorney with Shunnarah. We're based primarily in New Orleans. We've got offices in Florida, Alabama, Mississippi. We're soon opening an office in Chicago. We also have attorneys licensed in Indiana, Colorado, Wisconsin, and DC. And we're adding to that every day. I want to talk a little bit about some of the two sources of tension that are repeated issues with public adjusters, and mainly talk about the ethical considerations that we have as attorneys that sort of cause some of those problems. So problem number one is law firm you referred the case to won't talk to you about the case. Well, the problem is that the American Bar Association has model rules of professional conduct that dictate what attorneys can say on the duty of confidentiality to the client. So Rule 1.6, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. A lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to prevent, mitigate, or rectify substantial interest to financial interests of, or property rather, of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services. So that sounds kind of like it might protect you, right? Problem is that it's not a crime or fraud not to pay your public adjuster or your contractor in most states. So the way we get around this, attorney-client waiver of privilege. And you can do this on the front end. Have the client sign a waiver saying that they have permission, that the attorney rather has permission to talk to you about the case. This happens all the time, and frankly, it's something that you don't need to wait until the client hires an attorney in order to do it. The attorney is also going to ask for it. You can include this inside your contract. It can be a separate document. But either way, it's something to think about on the front end so that when you want a status on the case, you want to know, are you getting paid? What's going on? Is it in litigation? Did you file a suit? What's happening? That's something that they can discuss with you directly. Second problem. Why didn't the attorney acknowledge your fee? Why didn't they pay you? More model rules. In representing a client, a lawyer shall not use the means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such person. A lawyer who receives a document or electronically stored information, this one applies a little bit less to you guys, but that's the only rule that deals with what the duty is to third persons. So you guys would be third parties under that, right? This is the rule that deals with client money. A lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with a representation separate from a lawyer's own property. We have to keep the money in a trust account. We have to safeguard it. We have to secure it. Upon receiving funds or other property in which a client or third person has an interest, a lawyer shall promptly notify the client or third person. So that means when we get the money, we have to notify the third person who has an interest in that money that we received it. When in the course of representation, a lawyer is in possession of property in which two or more persons claim interest, the property shall be kept separate by the lawyer until the dispute is resolved. So if there's a dispute over the fee, we've got to hold it in trust until that dispute is resolved. But the problem is that unless you have a lien, you're not a third party under the definition of that rule. This is basically the equivalent of just owing money. It's like an electric bill. They owe you money, but you don't have necessarily a right to those assets. So this is how you avoid that pitfall, is you include in your contract a letter of protection, a line that expressly gives you a lien. Now, I'm going to show you some excerpts of different contracts here. Yeah, I'm personally licensed in Texas, and we have a small office in Texas, too. Our office is outside Dallas-Fort Worth. It's in, like, Arlington. Yeah. I'm licensed in Colorado. We don't have an office there, though, physically. Yeah. We're located in New Orleans. That's our main office. New Orleans and Florida now. It's a recent acquisition. All right, I don't know if y'all can read that. Okay, going back a little bit. Okay, so letter of protection. This is a provision that you're going to want to have either in your contract or in addition to your contract, but it really sets forth with specificity that you have a lien. This is an assignment of interest. This is the way sometimes people will do it. It designates the contractor or the public adjuster as a third-party beneficiary. It's not enough. Here's another one, very similar idea. And one thing I actually wanted to point out is yesterday one of the speakers talked about how he caps his fees at 10% because that's lawful in every state. Not quite. In Louisiana, PAs have to charge hourly. Only attorneys are allowed to collect a contingency fee. So always double check. Always talk to a local attorney before you start practicing somewhere. You do not want to be in a situation where you're figuring this out on the back end. You're trying to figure out how to get paid once you've already done all the work. It's much easier to figure out the compliance issue on the front end and avoid that headache. You raising your hand? Yeah. Yeah, it has to be hourly. Right, that is also true, but you still have to, on paper, in order for it to be enforceable, you still have to set forth an hourly rate. So same thing here, this also deals with third-party beneficiaries. It's still not enough. Likewise, this is another example, payments will be requested to be sent to the public adjuster, payable to the insured, and lender if applicable. Having the check sent to you and having your name on the check, not enough. So all of those, the language does not include specifically the word lien. That is really what you must include. And that means that when we settle the case and the client says, hey, wait a second, they want to get paid what? Well, if the contract doesn't say that you have a lien, then we can't hold the money. We have to give the money to the policyholder, who's the client. Our duty to them is always going to, supersede our appreciation to you that, you've referred us the case, but, ultimately, our hands are tied. More examples that are not quite enough. The insured hereby agrees not to accept any offer of settlement without the insured's approval, or the attorney, okay. The insured agrees to pay the hourly rate as well as any expenses, any and all costs associated by the attorney. The word lien does not apply. It talks about third-party beneficiaries. Not good enough. This one, likewise, same issue, talks about how you're entitled to the fees and entitled to reimbursement for all the work that you've done at an hourly rate, but not the magic language. Same with this one. Now here we're getting a little bit better. The insured and the PA acknowledge this contract does not encompass any legal services. If the insured decides to engage in litigation concerning the claim, the insured would be required to separately retain an attorney. The contract does not terminate if the insured subsequently retains an attorney. If the insured retains an attorney to assist in the claim, the PA will continue to add value to the claim by assisting and if directing by the insured and the insured's attorney. Almost there, but this is it. This is the letter of protection that you want to have. The client hereby instructs its attorney or future attorney to hold service providers' invoices for collection and to pay said invoices from any insurance claim proceeds received from the client's insurance claim and litigation relating to the same. Client hereby agrees that this letter of protection shall constitute a lien upon any and all proceeds received in connection with the insurance claim, and any right that the client may have to payment of the proceeds of the claim shall be subordinate to the service provider's rights. I'm not going to read the rest of it for you, but that's the language. That's what you need to have in order to avoid this issue. This particular provision is from a Florida statute, and you can see at the bottom it references it. That's the kind of language that you need in your contract in order to make sure that you're not having this issue. And again, this should be done before the fact. And if your attorney gives you pushback or asks, do you really have a lien? Point it out to them. Our obligation is always going to be to the client. We're not trying to screw you, but we have dual obligations, the obligation is always to the client. I think that expresses the point better than I could, right? So, two takeaways here. Get consent in writing from the client so that we can talk to them. We can update, or I can talk to you rather, about what's going on with the case, and get a letter of protection on the front end so that when you get paid, there's no dispute over whether or not we have to pay you. We don't want to be in a situation where, we don't want to screw you, but the client is forcing our hand. All right? That is my contact information. If anyone has any questions, you're happy to reach out to me. I'm happy to answer them. And that's it.